for those of us who practice within a private hospital, in terms of the Consumer Protection Act and the lease agreement that is drawn up between oneself and whoever the manager of the hospital is, this business of binding a clinician into duties to the hospital, how are we protected as the consumer in that situation?
Okay. There are two answers to that question, I think. The first is, obviously it's first prize to get a facility, to get an office in a private hospital, because that makes you a service provider of choice, because if the surgeon has a patient who's post-surgically depressed, he's going to call the psychiatrist in the hospital, generally speaking, rather than someone out the hospital. So from a bargaining point of view, you're probably going to have to give in more than you do if you're renting premises just anywhere there. Having said that, the terms of any contract in terms of the CPA have got to be fair. And the Act doesn't define what's fair. Once again, how long's a piece of string? But it does have regard to the relative bargaining strengths of the parties concerned. So I think as long as the supplier, the hire of the premises, could show that the conditions imposed on you, for example, are no more onerous than would be imposed on him. And there's no specific discrimination against you on any basis, but it's just normal market supply. There's tremendous competition for a radiological facility in City Park Hospital in Cape Town, and there's 27 radiologist firms that would like to get in there, and the one that makes the best offer gets it. That would be normal supply and demand. It wouldn't be unfair. But to the extent there's anything particularly oppressive in the contract, I'm just trying to think of what could be oppressive. Let's assume they say, well, we want you on duty 24/7, which is physically impossible. That would be an unfair condition. Whereas with regard to a radiology practice in a P1 trauma facility, you definitely do want a radiologist on duty 24/7. It would depend on the context. With regard to the rental and so on and so forth, once again, market forces would determine. The Act really much is designed to protect, I think, the weak against the strong. And as to whether a medical practitioner or a lawyer, whoever would regard it as weak in negotiating strength, would have to be decided by the courts. I think it's aimed more at the ordinary South African, if there is such a being out there.